When a defendant in a criminal case is convicted of a crime, it's time for the court to set a sentencing. What is that process like? Stay tuned. This is attorney Andy Marcantel and attorney Marc J, partners of the Attorneys for Freedom law firm, here today to talk about another subject in our continuing Fighting the State series. How's it going, Mark?
It's going great, man. Fighting the state is our favorite thing to do. Making these videos, educating people about really what's involved in a criminal case from beginning to end. That's what this is about. So yeah, I want to get right to it.
Yeah, we're going to talk about sentencing today, which is what happens after a criminal conviction. Now, our last video in this series, we talked about probably our favorite subject, which is trial. And we talked about all the ins and outs of that. And hopefully your trial is going to end with an acquittal if you have a good criminal defense attorney. But not all trials go that way, right? Lots of people are convicted at trial. Also, some people take plea agreements in criminal cases. And if either one of those happens, it's going to result in a criminal conviction.
Yeah, and it's also important to note that you can actually win a trial and still be convicted, right? There's this idea of a lesser included offense. And lots of times cases go to trial. Like a good example might be, say you are charged with and going to trial on, let's just say, first-degree murder, and your lawyer has asked for an instruction on maybe voluntary manslaughter or second-degree murder or negligent homicide or something substantially less, right? It might not be the kind of a case where you can say, all right, a complete acquittal here is what we're looking for. Sometimes that's a bridge too far, and you got to make that decision. That can be a hard decision, by the way, because you don't want to look unreasonable in front of a jury. But getting a case that's charged with and goes to trial on first-degree murder and winds up with a negligent homicide or something along those lines, that's a big win, but you're still going to sentencing.
That's right. And even if you're acquitted on some counts that you're originally charged with and you're convicted on others, even if they're lower-level offenses, if there's at least one conviction back from that jury, you're going to sentencing. And as we've talked about in the past when we talked about our whole plea negotiation section, is that when you enter a plea, you're pleading guilty. And the statistics are pretty clear there in American jurisprudence, and it's about 96% nationwide, give or take a few percentage points, depending on the jurisdiction, of cases end up with some sort of a guilty plea.
Yeah, this is why experienced lawyers really start thinking about sentencing from day one, even though you can do two things at the same time, right? You can vigorously, aggressively defend the case, and that's one path you need to start thinking about right from the beginning. But also, just in case things don't go perfectly well, just in case your client decides to take a plea, this can even happen in the middle of trial. That's not the time to start thinking about sentencing.
Right.
You got to start thinking about sentencing way at the beginning of the case. So you got to do two things at the same time.
Okay, so let's start by answering the question, what is a sentencing? And just kind of in a nutshell, some of the major points that I think people should consider is this is when the court now has a conviction in front of them, either a jury or a pleading and a plea deal is in front of them to some sort of an offense, and it's time for the judge to gain a lot of information from both sides, from both the defense and from the prosecutor, and from other sources too that we'll talk about, so that they can make a decision on what is the most just sentence in the case. What's the proper outcome? What type of a formal punishment is going to be given for this particular crime? Are there restitution issues? In other words, are there victims in the world that need to be compensated for the conduct of the defendant? So it's a time for the court to get as much information from as many relevant sources as they can so they can justly pronounce sentence.
Yeah, people who have been following this series right from the beginning will recall that I like to break down criminal cases really into three phases. Phase one, where are you going to be? Well, we're working on the other stuff, right? That's the question. It's always the urgent question at the beginning, right? Because lots of cases start, there's an arrest, somebody's hauled off, they're in jail. That's a big fight, right? Whether the person's going to be in or out. But that gets resolved at some point. I mean, the person is either in or they're out, and that's the end of that phase. The next phase we like to call the guilt phase. This is all about, is somebody going to be guilty of something And if so, what? This is what we just talked about. Maybe you're not guilty of what you were charged with. You might be guilty of a lesser included offense. You may not be guilty of anything at all. But if you are guilty of something, then you move to the third phase, which is, okay, now that you've been found guilty, either you pled guilty or you were found guilty at trial, the punishment phase. So now it's, forget about, the argument about whether you're guilty or not. You're guilty. At this point, you are guilty of something. But there's still a major question left on the table, which is what to do with this person who is guilty of something, because it's not all the same, right? There are many different factors that influence a judge's decision in terms of the sentencing. What the person did, well, that's one of the factors, right? And there are many different aggravators and mitigators. There's also their past background, what they've done since then. All of this becomes very relevant to a sentencing determination in the third and final phase, the punishment phase.
Yeah, and a lot of people ask, too, what kind of discretion does a judge have at sentencing? And the most accurate answer to that question is it depends, right?
Yeah.
There are many, many different factors because, some people have the misconception that if I get convicted for anything, the judge could just send me to prison. If I get convicted of a misdemeanor, the judge could just send me off to prison. If I get convicted of this crime or that crime, the judge could do this or that to me. And that's not exactly accurate. It depends. It depends on the level of crime. All jurisdictions in the United States break their crime kind of into different levels. Felonies, misdemeanors, petty offenses, and usually each of those jurisdictions will have kind of guideline ranges. Sometimes they're in the form of sentencing charts, sometimes they're in more discretionary guideline ranges, but every jurisdiction is going to say, for this type of crime, here's kind of the starting point that the judge has this range that they can give you. Of course, then there's other considerations, like does this person have prior convictions? And if the answer to that question is yes, are they eligible? Are they eligible prior convictions? All that really means is, did they occur recently enough in time, according to that jurisdiction, to come in to enhance the sentence?
Yeah, and there can be different uses of that prior conviction. Sometimes they're eligible, which gets you into a different box of range for sentencing, and they may not be eligible, but it might still be something that the judge can weigh. And, also there are questions that arise at this point regarding mandatory minimum sentences, right? So sometimes you'll get a judge who says, I'd really love to put you on probation, but I can't. Or I'd love to give you a sentence of X number of years, but I can't because the law says I have to give you X plus Y. I got to give you more time. And so these are especially common in firearms-related cases. Mm-hmm. Many different states have laws, sentencing statutes, that if you are using a firearm, maybe it's a dangerous offense or something along those lines, that puts you in a completely different category. And in many cases, probation, which might otherwise have been available, is now not available, and the judge has to put you in prison. And I have had situations where, at least in my 30 years of practice, where a judge has been on the bench wanting to give a lower sentence, but couldn't because of mandatory minimum sentencing. I think it's also important just to reiterate that the idea of mandatory minimum sentences, I think, can and has been used as an area of abuse. I think legislators are aware that if they really jack up the punishments on a lot of these crimes, people are going to be unwilling to roll the dice and go to trial. And it can result, and I think it has resulted, in such a high percentage of plea bargains because people really are afraid. When you're looking down the barrel of a 20-plus year mandatory minimum sentence, and the prosecutor comes in and says, hey, I got something, 6 months and you're out, or probation. Whether you're completely innocent or not, this is something you're going to want to consider just because you are reasonably concerned about putting decades of your life in the hands of a bunch of strangers you really don't know much about.
Yeah, this is the disparity of bargaining power that we talk about that's inherent in our current system with prosecutors. I think they're given way too much discretion.
And the sentences are too long.
Yeah, and of course, our crowd has heard us rail against mandatory minimum sentencing in the plea negotiation section of this series, where we argued that prosecutors are given too much discretion in alleging these things that create mandatory minimum sentences. So if you want to see a full breakdown of that, go back to plea negotiations. But on the subject of plea negotiations and how they affect the judge's discretion, sometimes the parties get together during plea negotiations and essentially deprive the court of any discretion. We might call this a stipulated sentence. What that means is that basically the state and the defense got together and we said, all right, after some back and forth negotiation, perhaps we've determined that this exact sentence is the appropriate punishment for this particular offense. Maybe it's an exact number of days in jail, an exact amount of years on probation, an exact amount of fines. And if we have such a stipulated sentence, the judge isn't going to have much discretion at sentencing.
Yeah, and some judges will reject these kinds of deals and say, I don't want my hands tied like that at sentencing. I'm not going to accept such a stipulated sentence.
You know, sometimes the parties can't agree on what to do with a plea deal, and we might make something that we kind of refer to as a no agreements deal. And there are different names for this type of a deal, but basically the agreement between the parties is there is no agreement. Let's leave it totally within the discretion of the judge. Maybe the judge will give prison. Maybe the judge will give probation. Maybe the judge will give probation with some jail time or maybe some deferred jail time. This is the type of deal we make when we feel like we have strong mitigators and we're kind of far away from the prosecutor on what we think an appropriate sentence is. The prosecutor might say, oh, this is definitely a prison case, no brainer. Any judge would give this person prison. And we might be on the total opposite end of the spectrum. No, this should be a probation case. And sometimes the parties will make an agreement to say, okay, let's duke it out in court. Let's leave the discretion to the judge. No agreements. He agrees to plead guilty to this particular offense. Here's the range of things the judge can do, and we'll see you at sentencing. It's time to put on a big battle.
Yeah, it always drives me crazy when a prosecutor says, and this happens a lot, as you know, you probably know what I'm going to say. When a prosecutor says, look, Mark, this thing is such a prison case. No judge would ever give this guy probation. It's never going to happen. This is a prison case. And I say, well, then let's do a no agreements deal and put probation on the table for the judge just as an option. And they say, no, we're not going to offer you that kind of deal. And I say, well, why not? Are you now not confident that the judge is still going to send him to prison? I mean, that's what it really reveals, that this is a prosecutor who's actually not that certain that everybody would agree that this is a prison deal, because the prosecutor is concerned that the judge might actually be convinced to give probation. And indeed, many of these over my career, when we get no agreement deals and probation is on the table, the vast majority of these, we go in and do the kinds of things we're going to talk about in this video and get exactly that, probation.
Absolutely. And before we get to that, because that's definitely going to be our favorite section of this video, which is preparation for the sentencing, the strategy that goes into what's going to be presented and how we prepare all of the information that we're going to present. But before we get there, I think we should say a few words about procedure. So first question is, when does a sentencing occur? We've touched on that, either after a change of plea to accept some sort of a guilty plea or after a conviction for anything at trial. Typically, a different hearing will be set for the sentencing. So, for example, if you go in and you accept a plea, which we oftentimes might call a change of plea hearing in many jurisdictions, they'll set a sentencing out, usually somewhere around 30 days, maybe a little longer. It really depends on how much work needs to be done in between the change of plea and the sentencing. Some cases are much more complex than others, and some cases have lots of complex issues at play, such as figuring out restitution and things like that. But eventually, the judge will decide on an amount of time between that change of plea or conviction for that sentencing, and that's when the lawyers really go to work and there's a whole lot to be done. I did want to note, though, that oftentimes in most jurisdictions, almost all of them that I've seen in the United States, if it's a lesser offense, such as a misdemeanor, a lot of the time, most of the time, the judges will go immediately to sentencing, usually in the same hearing as the conviction. They'll immediately move right to sentencing. Even following most misdemeanor convictions at trial, the judge will then immediately move to a sentencing hearing.
Yeah, a lot of these misdemeanors are fairly routine, right? I mean, say you're looking at a first-time DUI. They know exactly what the person's going to get. You know, a lot of them will say, we're going to stick you in jail for 24 hours. You got fines, you got counseling, you got this. That's the same thing you frankly would have gotten if you had taken the plea. So there's really no mystery there. In the bigger cases, the felonies, where the decisions are significant, you might be, there could be a 5 or 10 year swing on that decision. The judge doesn't really know much about the defendant. Remember, the judge doesn't get the police report or hardly any background information in the court file. So I think correctly so, before a judge wants to pronounce sentencing, the judge is going to say, I want some information about this person, so we'll set it off for 30 days. And then usually there's some entity in the court system, right? Maybe a probation department or people who actually are working for the judge, who will then go out and do a brief interview and gather some background information so they can present that, so that at least there's something in front of the judge for the judge to read, to get a feel of who is this person I'm getting ready to impose a sentence on.
Yeah, that's why we typically in felony cases will set that sentencing out so that we have time to educate the judge on those things and employ some of the strategies that we're about to break down. But I did want to mention as well that in rare cases, sometimes felonies can go right to sentencing immediately following a change of plea. And this is usually in those cases of a stipulated sentence like we talked about. Everybody agrees what's going to happen to the defendant. Everybody agrees the judge has no major discretion regarding anything about the sentence. Let's save some judicial resources and the resources of our client who's paying us to show up every time. If we make the determination with the client, look, we're not really going to get any mileage out of drawing this thing out and all having to come to court again and everything like that. Plus, there might be strategy reasons why we want to move right to sentencing. We might notice some advantage, and if the client authorizes us to, sometimes we can go straight to sentencing, even in a felony case.
Yeah, all that's true. It's pretty uncommon because sometimes a judge will say, even though I got a stipulated sentence here, I don't know, maybe this guy's got other charges pending in another state, and I want that background report just because I want to, do a thorough job to know what else might be out there that I should know about. Because once the judge pronounces sentencing, most of the time, with very few exceptions, that's it.
All right, so the procedure for a sentencing hearing, here's what happens, and it's actually pretty straightforward. Everybody shows up to court on the agreed-upon date. You're up there at the table, the defense table, with your attorneys. The prosecutor shows up, and then the judge calls the sentencing, and usually the state or the government attorney, the prosecutor, whether it's state or federal, usually they'll go first. And what they do is they give their version of the case. They'll talk about the facts of the case. They'll talk about things we call aggravators. These are things that are recognized in the particular jurisdiction that make it worse, make the impact of what this defendant was convicted of worse. And the reason why the prosecutor is bringing up these statutory aggravators is they want to convince the judge usually to go on the higher end of punishment with whatever discretion the judge has in that particular hearing. Also, the prosecutor has the option at this point to present witnesses. And the types of witnesses that you would see in a case very commonly would be something like a victim impact statement. Say that there is a victim of the crime that the defendant was convicted of. They can bring the victim up. And in fact, most states, Arizona included, have a constitutional right for the victim to make a statement at the sentencing. And oftentimes a victim will go up and make a statement. We've had cases before where the victim's dead and the victim's family gets up. The next of kin, the mom, the grieving widow, whoever it may be, gets up and makes statements about how this has impacted their life in a negative way, and then make a recommendation to the court about what they want to happen with the sentencing and with the judge's discretion. Other types of witnesses might include police officers. I actually pretty recently had a first-degree murder case where, in addition to victim impact statements, the prosecutor called up the lead officer in the case to go and address the court and say, Judge, I was the lead officer in the case. When I showed up, the whole scene was a bloody mess, and I can tell you this is one of the worst cases of this kind I've ever seen in my career. I'm sure he said that at the previous two hearings with the similar charges. But they can bring up whoever they want to try to convince the judge to lean more on the side of aggravators.
Yeah, I mean, in putting my citizen hat on, I certainly like the idea that victims have a right to be heard in court. I think it's also important to note that victims sometimes hire attorneys to represent them to do exactly this. I mean, we've done this ourselves.
Do lots of them, yep.
We've done lots of them. And, I rather like showing up in court representing the victim who may or may not still be sitting there. And you get to pound the table a little bit and make the argument to the judge. I mean, the defense attorney hates it, but this definitely happens. It's also something, I'll just note, that this actual representation of a victim, to my knowledge, AOR is the only program that offers such a representation service. I'm not aware of any other program anywhere that actually puts a lawyer out there to represent victims in court in self-defense cases besides AOR. It's something we love doing. That's why it's in there.
Yes. We love doing victims advocacy for our AOR clients, but I'll tell you my favorite, Mark, and we got one in the office like this right now who I believe is going to be coming in to tell his story pretty soon on the podcast. My favorite cases are when our client initially is the defendant.
Yeah.
They're charged with the crime after the self-defense incident. And then we get to defend them, we get to get the case dismissed, and then we get to convince the prosecutor to charge the other person. So that's my favorite form of victims advocacy.
I sure hope we can talk about this one. And, people know that because we're a law firm, these other companies can put anything they want out there. As we've seen, they can even disparage people in their program if they want. But we're a law firm, and we're professionals, and we can't talk about anything. We can't even say we've represented somebody unless they have been educated about what their rights are, and then they've specifically signed in writing a release that allows us to talk about the case. So, what we just said is about as far as we can go. But hopefully we can say more on these. But yeah, these are definitely fun, especially when they start as the defendant in the case and we get the case thrown out and then get the person who previously was seen as the victim now charged as the defendant, and we get to go into court and raise hell against that defendant. So those are super fun. But yeah, that happens in sentencing cases, and you really got to be prepared for that if you're representing somebody and an attorney shows up to toot the horn of the victim and ask for a lot of time. You got to know how to deal with that as an attorney representing a defendant in court.
So after presenting their witnesses and whatever evidence, even sometimes they'll show exhibits to the court. I've had certainly prosecutors play videos and things like that of the incident, maybe audio, victim impact statements, things like that. They'll make a recommendation at the end of their presentation. They'll say, Judge, based on all that stuff that you just witnessed, here's what we want you to do. And the state will make a recommendation to the court.
Yeah, and this is one of those things where, you talk about getting every little advantage in the case, right? And so there are occasions when you can go to the prosecutor and maybe offer them something in exchange for, how about you don't stand up and pound the table and ask for a big, long sentence? This is sort of an informal deal, right? Instead, maybe you just sit down there and says, Judge, we leave it to the court to decide the sentence, or maybe you don't play the gruesome video or something like that. These are little, what I'd call informal side deals that you might make an agreement with the prosecutor, and sometimes they're willing to do these. And again, you're fighting for what might be a difference in years of somebody's life in a cage. And so any advantage that you can get, even if it's an informal one, to just get a prosecutor to not be as animated as they would otherwise be in aggressively asking for more time, maybe to dial that back down, definitely has some good benefit for a defendant at a sentencing.
So that's the end of the state's presentation at the sentencing, and we move on to the next phase, which is the defense's presentation. And we're going to do more or less the same thing. We're going to offer all the mitigation. These are statutorily recognized factors that vary jurisdiction by jurisdiction, but they're mostly the same between jurisdictions. There are certain things that you want to show are present for your client's case. You mentioned a few of them earlier. You talked about background. You talked about family history. You talked about substance abuse. You talked about the context of what happened in the actual incident and how understandable humanizing factors could have led to the infraction being committed.
Yeah, I like to tell people that at this phase, you can't just phone this thing in. I like to tell people, think of this as a trial just on the issue, not on the issue of guilt, but on the issue of what should the sentence be. You really got to bring it here. And so you need to calibrate your presentation, right? How many witnesses are you going to have come in? Who's going to go first? What are they going to say? Have they also submitted letters? What's going to be different about their oral statement in court that differs from what the written letter they submitted? How many letters are you going to submit? Sometimes letters have things in them where you look at them and you're like, I don't know if this helps all that much. And you really got to sort of calibrate your presentation to the judge between written materials and live in-court materials. You also got to read the judge. Sometimes the judge has sort of got it and has heard it, and more isn't going to help you. And other times you can tell, this judge needs more convincing. I got to lay it on a little bit heavier here so the judge understands what our position is.
Yeah, all of these sections of the Fighting the State series really reference one another. We talked about this same concept of reading the judge when we talked about oral argument in a previous episode. And this actually happened to us in court last week on a major federal sentencing. There was a point that we thought was going to be a huge point of contention, that we thought we were really going to have to argue with that prosecutor for. And the prosecutor essentially just conceded the point. And we were kind of gearing up and ready to go and excited to argue this point. And the judge basically told us, I got it. I'm going to side with the defense on that. And so we're like, all right, sounds good. Move on to the next point. We were ready to speak about that for 15 minutes.
Yeah, you and I were in court just very recently in Washington, D.C. on a very high-profile federal case. And, it was interesting because there are lots of decisions to make on that case. What's the defendant going to say? How's he going to say it? What's he going to say? What witnesses are we calling? Who's going to say what? I had a lot to say in front of the judge on that. And I actually changed what I had to say in the middle of saying it because, in that case, it just happened to be where the lectern was where I was standing. I had a very good read on the judge's facial expressions, and I could tell that this judge was really listening to and agreeing with things that I was saying. So I don't want to, when you're ahead, you can only hurt yourself. Mm-hmm. And so I sort of calibrated down some things I was going to say. But also we had many, many other things that we used in that sentencing, like, for example, an expert's mitigation report. And as I recall, in that case that we just finished, there were 31 people who were interviewed by our mitigation expert that went into this report. And, like we were just talking about, there's going to be a pre-sentence report. But these are sort of cookie cutter, and they come from a neutral party who works for the judge. Why settle for that? What I would want if I was going to a sentencing is I would want the lawyers to hire an expert, somebody who has better credentials, who's been around much longer and seen much more than the person who's writing the pre-sentence report. And I'd have that person do a much more extensive deep dive with interviews and looking at old records and really tearing the thing apart so we can say, to the extent the two reports differ, our report is the one that the judge should go with because it's just more thoroughly, comprehensively done. And, this isn't something you can start thinking about on the day where you finally find out for sure you have a sentencing. This is something you got to work on right at the beginning because it takes months and months and months to get this lined up. Maybe wasted time, right? You might go to trial and get a not guilty on everything. You might take a plea and have a stipulated sentence. But this is what you need to do.
It's better to be prepared and not need it.
Absolutely.
And I explain this to clients all the time. A good attorney fights the case zealously and advocates for you in that penalty phase, but is also prepared for a worst case scenario. And I think it's irresponsible when attorneys just start thinking of it a week or two or a few weeks or right after the conviction. It really is something that you got to think about for months and basically the duration of the entire case. You got to at least keep some strategy decisions in mind aiming towards a sentencing.
Yeah, and sometimes clients don't like this, right? Because day one, all they want to talk about is this is my defense and, what are we going to argue? And then you start talking about, well, we might need a mitigation expert. And they're like, huh? Why? I said, well, in the event you decide to take a plea, they may say, well, I'm never taking a plea or there's no way we're going to, okay, fine. But we still got to be prepared, right? I've been around the block much more than the client has, and that's why you hire a lawyer. And so our job is to be prepared for all contingencies. So you got to start thinking sort of three-dimensionally and be proactive right from the beginning because you don't know. You never know what a jury is going to do. You never know. Clients change their mind on cases as well. You just don't know what's going to happen. I've had clients change their mind on the eve of trial. I've had in the middle of trial. We've made deals even after trial. So anything is possible. You don't normally get a do-over. So you really got to work simultaneously on sort of different goals here from the beginning.
So let's get back to the courtroom for more procedure. The defense is presenting things now. The state has rested. The defense is presenting character witnesses, expert witnesses, mitigation witnesses, exhibits. We're having people come up who know the defendant, who have some things that they can offer to the court to humanize them. And then we give an oral argument. We will sum up everything. We'll highlight the points, the important points, and the relevant points for the judge. As you just mentioned, you have to be very malleable in these types of hearings. Sometimes, as you just told the story of what happened to us last week, you can read certain things in the court and figure out that certain things are more important and less important to the judge. And so you have to be able to adapt. And then after you offer all of your oral argument and all of your evidence, typically at that point, the final word goes to the defendant in something in this country we have called an allocution. And an allocution is a right that you have as a defendant, but it's not a mandate under the law. The allocution is where, all right, defendant, the floor is yours. Everybody's spoken. You've heard the state. You've heard the witnesses. You've heard the defense. You've heard the mitigation experts. Last person the court gets to hear from is the defendant. Is there anything you'd like the court to know? And you have an absolute right not to participate in allocution. And furthermore, you may not be penalized in any way, shape, or form for denying it. But if you do want to participate in it, you can say anything you want to the court.
Yeah, and I hate the idea that the defendant goes last. And, so many times I'll say to the court, Judge, with the court's permission, because it's just kind of weird. And so I say, with the court's permission, my client would like to allocute right now. And then after that's done, I'd like to make a few comments. The reason I do that, of course, is if the client screws it up. If the client says something wrong, then I want to fix that at the end. Also, if the client does a really good job, it allows me an opportunity to say, Judge, I know you believe that he's remorseful. We were both just standing here when he gave that statement, and I know you know that statement was genuine because we can all tell. And indeed, that's how I like to do things. And I've found that to be very successful. I've never had a judge tell me, no, sorry, Mr. Victor, the client has to go last.
I actually have before.
Oh, really?
Yeah.
That's
but
never
of course,
happened to me.
you can avoid these concerns about your client screwing up their allocution by giving them a lot of preparation ahead of time, keeping them on script, sometimes literally. It's a tightrope, though, because you want your client to connect with the judge. You want the judge to see that what your client is saying is genuine, it's from the heart. You want your client to make eye contact with the judge. So I never like the idea of whether it be the defendant during allocution or the character witnesses that we presented walking up to the podium with a pre-prepared written statement. So practicing with a client that statement and staying on script but still being able to be fluid enough to connect with the judge is an important thing too.
Yeah, nothing stops the judge either from asking the defendant some questions. Mm-hmm. If the defendant's going to put a statement out there, the judge could say, Mr. So-and-so, I wondered about this or that, or what can you tell me about this or that? And so you certainly want to do the best you can to prepare your client, but there have been times where I've said, excuse me, Judge, can I have a moment? And the judge will almost always say yes, and then I can sort of lean over and whisper in my client's ear and make sure they know what to say or not to say, or tell them to get off that point or something like that. So, look, you do what you got to do the best job you can for your client at sentencing.
Yeah, at the end of the day, judge runs the show. Some judges I've been in front of even say, well, today I want the defense to go first. The judge, there's no hard statutory rule in most jurisdictions that say it has to go in this order.
They also sometimes will give the prosecutor another final bite at the apple.
The rebuttal.
Yeah, sometimes you do such a good presentation and the judge might say, I'm going to give the state another opportunity, or the state may ask for another opportunity. So the judge has got a lot of discretion to hear and make a decision about sentencing. Of course, the judge can say as much as the judge wants to say at sentencing too. And indeed, that one we just finished up in D.C., the judge had a lot to say, and it was really very kind. And I think these are the better judges out there, the ones that take some time and really say some things which include some words of encouragement to the defendant. And so to me, those are the better judges. I think that is a proper time for a judge to sort of say, here's how I see things, and maybe dispense a little advice and say a few things for the record, for the public, those kinds of things. So you've really got to be you can't be flat-footed at sentencing. Anything can happen, and you need to be ready to pivot and to deal with it and think on your feet.
Yeah, so allocution is now over. The defense has rested, and now the moment everybody's been waiting for, the judge pronounces sentence, and a number of different things could happen at this point. Your client could be put on probation, and if they get put on probation, there's going to be some discussion by the judge about what the terms of probation is going to be, and your client will have to sign some documents acknowledging they understand what is going to be required of them on probation. More dramatically, your client could be taken into custody if they get a jail sentence or a prison sentence that they're required to start that day. The sheriffs could come over and slap handcuffs on your client and take him out of the courtroom. Never a fun moment as a criminal defense attorney, but it does happen sometimes in more serious cases.
Yeah, and you really got to prepare the client for that, right? Because sometimes clients come in and they have high hopes, and if they get taken into custody, they haven't made arrangements with their jobs, their kids, and things of that nature. That can make it extra traumatic. So you really need to advise your client on all the possibilities, as well as the character witnesses, right? They need to know what the judge could possibly do at sentencing so they can speak to that. I never like having my client, the defendant, actually ask for a specific sentence. I think it always plays better when the defendant says to the judge, and Judge, whatever you think is the proper sentence, I'm going to serve it and do my best to improve myself so when I get out someday, I'll be a better person. And I always tell them, look, you don't have, the judge knows you want the lowest sentence possible. I'm going to make it excruciatingly clear. The character witnesses are going to make it excruciatingly clear. But I think it's generally a bad look for the defendant to say anything other than, look, I'm prepared to accept whatever you think is an appropriate punishment for the thing I just did that I now regret and wish I could change. I think that just presents the client in a much better light.
Yeah, a couple little procedural points here to put a bow on the actual procedure of a sentencing. This is also a time at the pronouncement of sentence for the judge to make certain legal findings on the record. So, for example, take a crime like aggravated assault. You say we have a client who's convicted of aggravated assault. This is one of those nasty mandatory minimum sentence things here in Arizona if it's done with a dangerous weapon like a firearm. And so there's this range that the judge has. On the very low end in the mitigated sentence, they have 5 years. Then there's the presumptive sentence, the middle kind of starting point of where the judge starts, of 10 years. Then there's the aggravated sentence of 15 years. And say both sides have been arguing, prosecutor wants to pull the rope over here and we want to pull the rope over here. If the judge goes anywhere other than the 10-year presumptive, the judge needs to make certain findings for the record. So say that the judge says, all right, you've convinced me, guys, I'm going to give your client the mitigated sentence. The judge, as a point of procedure, actually has to find on the record that the mitigating factors outweigh the aggravating factors, and therefore I'm going to give them 5 years.
Yeah, I mean, a good judge will say on the record, I specifically find in aggravation the following things. They also will say, I find in mitigation the following things. Also, good judges will come right out on the record and say, here's what I've reviewed. I've reviewed this, this, and this, and this from the defense. I've reviewed this and this from the state or the government. Is there anything I'm missing? Right? Because they're doing this for a reason, right? Because if they haven't reviewed something that was submitted, you might have an argument for resentencing later down the road. So good judges will come out on the bench and review that and ask the question, is there anything, else that I didn't review that I should have? And every once in a while, there's something, right? They didn't receive a letter or something like that. And of course, very bad form to be submitting things at that moment to the judge. You want to make sure you get everything you want that judge to read to the judge well in advance of sentencing. And also, little tip for lawyers practicing, you might want to tell the judge or the judge's judicial assistant, we got some witnesses who are coming in. We got 5 witnesses. We think they're going to need X number of minutes each one, and talk to the judge to make sure that the judge is not surprised that you got witnesses you want to come in. And of course, the witnesses can be done different ways, right? The most popular way is to just bring somebody up and have them stand there and just talk to the judge. But another possibility, and sometimes prosecutors insist on this, is I want them under oath up on the stand and put them on the stand, and now they're subject to cross-examination. That is far more rare, but I have had it happen before, and it will happen if a prosecutor thinks that maybe this person is lying about something and they want them on the stand under oath, so they're subject to some kind of a perjury charge if they're lying.
Yeah, and on the subject of giving the court a good heads up, just as a term of practice here, good practice as lawyers, in addition to saying, heads up, judge, there's going to be this many witnesses, you also kind of want to do a time calculation for the judge. Yeah. The burden usually falls on them. The state doesn't care. They're in court all day. They're popping between the courts and everything like that. Usually the big presentation in these hearings is from the defense. And we usually have way more witnesses. We usually have way more mitigation experts, everything like that. We're pulling hard on that rope trying to get it to our side. So really, because we take up a bulk of the time of the sentencing hearing, the burden kind of falls on the defense attorney to make sure that enough time is requested on the court's calendar to accommodate this type of a hearing. So oftentimes we have to do a calculus where we're like, okay, we've got this many witnesses that are each going to speak this long. We have this expert who I expect to speak this long. I'm going to need this much time for my oral argument. My client needs this much time for their allocution. Therefore, I'd like to request the court well ahead of time for 2.5 hours for a mitigation hearing that we call them in Arizona. And so that's a courtesy heads up to the court that I got a lot of stuff that I got to present to you, Judge. And we have a right to request that kind of time, depending on the complexity of the case. So I wanted to mention that procedurally. It's a good idea. And the judge, if you show up on the normal morning calendar and the judge was expecting this to be a 5-10 minute hearing, and you're like, all right, Judge, I've got 8 character witnesses and 2 experts that all want to talk to you. Just as a practical matter, the judge is going to be upset.
Yeah, and smart, savvy, experienced lawyers know that if they got a big hearing, might not be a bad idea to let the judge know back in chambers at the hearing before that and see if you can work something out for sentencing that is favorable, right? Because, if you're back in chambers and you're sort of having an informal discussion with the judge, and of course, if you're going to do this just for people who don't know, you have to have both sides there. Neither side gets to just, as we say, ex parte the judge. So both sides get to be there, but it's not uncommon in state court to do this. In federal court, you almost never do this. But in state court, it's not completely uncommon to go back in chambers and say to the judge, hey, look, judge, just want to let you know, we got 2 hours of things and all these witnesses. But on the other hand, if you're thinking probation, maybe we don't need to do all this. And sometimes you can get a judge to say, maybe for the purpose of avoiding all of that time, yeah, I'm kind of inclined to do probation. All right, Judge, well, we'll do that. We'll come in for the regular sentencing. But if you decide you're going to change your mind, let me know, because we can always do that big, long, drawn-out 3-hour hearing that you really don't want to do if you change your mind. You'd be surprised. Well, you wouldn't be. People would be surprised at how effective this can be.
Yeah, our viewers are getting some real insider baseball right now. Yes, conversations like this happen in chambers where we'll grab the prosecutor and we'll go back and we'll have a conversation off the record in private with the judge and say, Judge, we've got 2 options here. My client has a right to a 3-hour hearing that I'm inclined to request because there's so much time on the line. However, Judge, how about I submit a memorandum to you and maybe we can set a little status conference or something. And if you're telling me you're inclined to do probation, I'll tell you what, I won't request the 3-hour hearing. Let's set it for the morning calendar and knock it out in 5 minutes.
I've actually had some judges who were happy to kind of negotiate this back in chamber. I had a judge one time who said, well, okay, I'll give him only, 3 years or something. And I said, nah, Judge, we really want to try to talk you into 2 years. Maybe that's the best we can get under the deal. And Judge said, all right, fine, I'll give you the 2 years. Let's not do the hearing and move on. Put yourself in the position of a judge, right? They don't get paid any more or less money if they spend more time in court. And especially if the day that you're setting the big hearing is on a Friday afternoon or something like that, you might incentivize them a little bit to just sort of move the thing along.
Yeah, people shouldn't attribute this solely to laziness, though, as we've mentioned in previous videos, we certainly like to take advantage of the laziness of who we're dealing with in the justice system. For example, in plea negotiations with prosecutors, we like to file lots of things and create lots of work with them, so they just want to get rid of the case. But this is also a tactic used by good judges who want to preserve judicial resources. Yeah. If the judge knows, look, I'm inclined to give probation on this matter. There's no reason. Yes, right. He's got a right to a 3-hour hearing, but this would be painful for the next of kin to go through on the victim's side. This would cost many thousands of dollars. We'd have to take police officers off the beat. The character witnesses for the defendant would have to take days off of work. If I'm just inclined to give the same result anyway, let's skip it, and the judge could mediate such a settlement.
Yeah, you and I have also had the opposite, where we've said, hey, Judge, look, we have this big hearing planned. If you're inclined to kind of do this, we don't need to do that. And the judge would say, I'm not going to tell you what I'm
they say, I want to keep the cards totally secret. I don't talk to defense attorneys about that type of thing.
Yeah, and then it's like, okay, we got to do the big hearing.
Sounds good. See you next week in court for 3 hours.
Yeah, so experienced judges will generally, at least in the state court, this is not we should talk about federal court separately, but in state courts where things are a little bit more informal and the system is maybe a little more burdened with cases and time is maybe a little bit more precious on the court's calendar, experienced judges may be a little more willing to kind of tell you what they're inclined to do. And then based on that, you can kind of calculate. Because, look, the point here is to get the best sentence. It's not necessarily to bring as many people into court who are itching to talk to the judge. If you can get what you want a different way, you get what you want and you move on. We're very goal-oriented at sentencing.
So let's talk about a few really important things that we do when we got that sentencing date coming up. What are we doing to prepare strategy-wise for that sentence? What's the procedure like? And probably the most important filing that we make leading up to the sentencing, we might call it a sentencing memorandum. They have different names in different jurisdictions. You might call it a mitigation report or a mitigation memorandum. But it is basically a collection of all of the different mitigation in the case, expert reports, character witnesses, letters attached from them, a summary of our client's background and history and the context of the incident and the mitigating factors at play from the statutory law. And we lay it all out in a really nice package so that it's all there for the judge and we file it. And also at the end of such a memorandum, we'll kind of give a preview to the court of here's what we plan on asking you for that day.
Yeah, it's essentially our best pitch in writing with all the exhibits. And just so people are clear, this is the sentencing memorandum that the lawyer drafts up. The state can also draft one and ask for more. Previously, we were talking about the report from a mitigation expert, right? That's a separate report. Sometimes we have a report from a psychologist. That's a separate report.
Yeah, those things will be exhibits to our big, giant sentencing memorandum.
Yeah, and we may have a bunch of letters that are also included. We may pull out some of the best little quotes. John Smith wrote you a big, long letter, and one of the things he said was, I've never met a better guy in my entire life than, the defendant here. We might pull that out and put that in bold, especially if it's somebody who's known the person a long time. It's okay if the judge reads it twice. You don't want to put the whole thing in there twice because, judges will get cranky if you keep presenting the same thing over and over again. But there definitely is an art to how you present this at sentencing. And also with the lawyer's comments at the end, you don't want to just rehash everything that's in that sentencing memorandum. You want to say something a little bit different. You want to try to inspire the judge to do something. And, it's great when the judge came in all ready to give a more harsh sentence and you change the judge's mind and they gave something a little bit lighter. That can happen and often does happen at sentencing.
I love it when I hear that. It's at the end. They almost look like they're pained a little bit, Mr. Defendant, I was planning on coming out here and sending you to prison, but your attorney convinced me to give you probation, so don't screw it up, kind of a thing.
It's nice when you hear that as a lawyer, that you change the judge's mind.
So now, leading up to that sentencing, the judge has heard from us in a big, giant primer that we might call a sentencing memorandum with tons of exhibits and mitigation. The judge has heard from the state in their own sentencing memorandum, and same rules apply to them. They can attach things as exhibits, whatever they want the court to know. But there's a third party that the judge will often want to hear from, and that is the quote-unquote neutral party of the probation office that is assigned to the case. And how that works is, the idea here is the judge is like, okay, the defense is kind of biased towards the defendant. They're only telling me the mitigation. Also, the state's biased towards the state's presentation. They're only giving me the aggravation. I want to hire a neutral party to go do an independent investigation and make a recommendation to me in something called a pre-sentence report. We might call it a PSR PSR for short. And how the probation office generates the pre-sentence report is they assign a probation officer, and that probation officer will go and conduct an interview with the defendant in the case. This is called a pre-sentence interview, PSI for short. And based on that interview, they'll generate a lot of information. They might come up with something we might call a risk assessment score based on their answers to the questions. And these questions, I mean, there's a lot of them. Usually there's well over 100 questions. Usually this pre-sentence interview can take an hour or more, and it's kind of rapid fire questions. A lot of them are form questions. I've never encountered a pre-sentence interview where I was totally surprised or shocked by some. So we have a really good idea of the types of things that our client's going to be asked. And eventually, after asking all those questions, they generate a report and they submit their recommendation, the neutral party's recommendation to the court. Now, to our viewers out there, Mark, I'm sure you know, but the reason I keep using the scare quotes when I say neutral party is because, of course, the probation department is the state. It's a state entity. Yes, it's separate from the prosecutor's office, but it's still the state and it's still taxpayer funded. And so that's why I kind of cringe a little bit when I say the neutral party.
Yeah, and the defense attorney who's really doing their job aggressively is going to first prepare their client for this interview. And you might even decide you don't want the client to talk about the offense and just say, look, we're not going to talk about the offense. Here's the factual basis. Use that. And then secondly, you may want to accompany your client down for that interview. I like to do that just to make sure things go smooth during the interview. And also, it's a nice chance to kind of work over that pre-sentence report writer a little bit and highlight some of the mitigating things that you want in that report. Right? You'd like to do as little heavy lifting as possible. I mean, the ideal situation is to get the recommendation in that report to be exactly what you want and not different. Because if that's different, now you got to explain why you're asking for something that the quote neutral person wasn't asking for. And obviously, we're going to want something better than the average person in that situation gets. And they're going to do their best to say, look, most people get something along these lines here. That's probably where their recommendation is going to come in. We're going to say, no, there's something different about our client, our case, the facts. Something here is different. Our client should get a more favorable sentence than the average person in this situation. So, again, you don't want to lose any advantage you can possibly get here. You know, sometimes this doesn't get you anything, but if you don't turn over the stone, there's no chance of finding what could be some treasure underneath.
Yeah, most judges weigh the probation department's recommendation very strongly, considering the biases at play from the parties who were involved in the case. And I have had judges say on the record before, defendant, I was thinking about treating you more harshly, but because the probation department recognized that you have a lower risk score or found this in their report, I've decided to give you a more lenient sentence. So, and different judges weigh things differently, but the probation department score, especially in a contentious hearing where both sides are kind of far apart on what they think, that neutral party can give a recommendation that might sway the judge one way or another.
Yeah, you want the wind at your back, and if you can get a good report there, you're not swimming upstream here.
And so given how important it is, in 100% of my felony cases where the judge has any discretion on the sentence, I have an extensive preparation meeting with my client before that pre-sentence interview. I've sat through hundreds of pre-sentence interviews, and so we have a very good idea of exactly what the questions are likely to be asked of the client. And we also happen to know how answering the questions could help or hurt the client. And we have a meeting where we kind of go over what to expect. And we can't tell clients what to say. A client can say whatever they want in an interview. What we can do is we can objectively inform them of here's the type of things that if you were to say could end up getting you into a higher risk assessment level. And here's the types of subjects that you may want to avoid. We certainly can't tell a client to lie, but a huge part of clients getting themselves in trouble and showing up as a higher risk assessment on these types of interviews is when a client can't close their big mouth and just starts talking and treating the pre-sentence report writer like it's a priest in the confessional and deciding to tell them about every single thing that's ever happened in their life, even outside of the scope of the questions, such that the person who's listening starts hearing what they consider to be little red flags and start taking up the risk assessment assessment score. So we need to have a big, long meeting with the client to prep them up because we want that pre-sentence report to be really good. And as you mentioned, very common practice at our office for us to actually attend that pre-sentence interview with the client. And I rarely allow my client to make any statements about the incident itself to the pre-sentence report interviewer from probation. Usually saying, look, he's not going to talk about it today, but I'd like you to put into your report that he is not talking about it on my advice and that he plans on making a full comprehensive statement to the judge directly at sentencing. And they're always okay with that. Okay, less work for me to do, says the probation writer.
But no matter how much prep work you do, there's still no substitute for sitting there next to the client so you can kick him in the side, tell him to shut up if he doesn't follow your advice. Yeah. So you got to do everything you can do to try to get a good result here.
Yeah. We also are preparing character witnesses leading up to the big sentencing date. And there's a lot to be done here. We want to talk to the different character witnesses, kind of get a feel for what they're going to say, understand what they can bring to the table in the capacity that they know our client in order to humanize that client best to the court. Now, you got to walk a tightrope here when you're preparing character witnesses. What you do not want is you don't want that person to sound like they were prepared by a lawyer. Mm-hmm. You don't want to sandpaper their statement too much so that that judge is thinking, oh, this isn't authentic. This sounds like a lawyer prepared a perfect statement. I love imperfect statements. Imperfect statements are great for character witnesses as long as they come from the heart, as long as they're genuine. You want that judge to think, this person right now is speaking to me on behalf of the defendant from their heart.
Yeah, and, people also are nervous coming into court and standing there in front of a judge, and I like to remind them that, look, this is just another human being wearing a black robe. I remind them to make eye contact, right, because this is your opportunity to talk to another human being who's got the power to do very important, serious things to your pal here, your friend here, your brother, your whatever your connection is to the defendant. So you certainly want to prep them. The last thing you want is them to come in and say, oh, the guy got screwed, the system railroaded him. I mean, you might feel that way, but somebody who's inclined to say those kinds of things, look, this isn't a time to vent your personal opinion. This is a time to do your best to convince the judge to do what we want. So, in a perfect situation, everybody comes into the office long before sentencing who's going to be a character witness, and you sit there and you explain exactly what it is we're doing, what it is we want you to say. I mean, who are you? How do you know this person? Why is this person a good person? Do you have an example? Has he helped an old lady across the street one time? Did he do something nice? You might lay a little story like that out there, and then you can ask the judge, I'm asking that you do this or that. I think all that's good. Plus, it also is a way to educate the judge about what kind of people are around this person, right? If you're trying to get the judge to do probation and the judge thinks this person's got nothing but thugs around him, the judge is going to consider that. If, on the other hand, he's got responsible people who say, look, judge, we know he made a mistake. I remember one time I did one of these, and it was sort of a young, he was still an adult, but he was, 18 or 19, pretty young. And the mom came in, and man, this mom was tough. And I'll never forget, the mom said, Judge, when you're done with him, he's got to face me, and I'm much tougher than you. And and the judge just ate it up. The judge loved that this guy had a tough mom out there in the world who understands what the person did, is realistic about it. If the judge thinks you got a bunch of kooks out there who don't help you take responsibility and are going to encourage you to continue to do bad things, that's something that factors in. So you really got to pick carefully who's going to come in as a character witness. I've had people who wanted to be character witnesses. I've said, sorry, I'm not going to call you as a character witness. I don't think you're going to help. And people don't like that, but it's our job to do everything we can to get the best result.
Yeah, we're not trying to make the character witnesses happy. We're trying to get the best result for our clients. So we got to make strategy decisions. And among those strategy decisions is things like order of the character witnesses. There is some art that goes into that. You want to present a certain narrative, a certain well-rounded story about your client. And so the order of presentation can be very important. Then there's just real life stuff. I get this all the time. What do I wear to court? When and where is the court? Where do I park? We're oftentimes the ringleader here at this point in making sure everybody is coordinated and on the same page and shows up looking nice and knows what to say and has their statement prepared.
Yeah, and I also thought you did something that was really effective in that hearing we just finished in Washington, D.C., because we called a handful of character witnesses, but there were many more people who showed up there to support our client. And, you turned and said, Judge, I just want to acknowledge all of these people. And you kind of gave a little overview of who these people were, where they've traveled from, and that even though they're not speaking here today, Judge, just want to let you know our defendant, our client, has a lot of support from a lot of good people who have come in. And it is nice for the judge to see that there's many more people out there who could have been called up to say good things. And I think, especially in the case we just finished, I think that made a very good impression on the judge.
Yeah, the judge wants to see a nice support system that defendant's going to have. And, even considerations, even if the judge ends up sending the client to prison, maybe they'll sentence them to significantly less prison if they believe that client has a good home to go to afterwards, that they're not just going to be dumped out on the street, that they have a good chance of rehabilitation. So, yeah, character witnesses, super duper important. We're also, leading up to that sentencing, preparing our expert witnesses. Oftentimes, we'll have our mitigation witness show up to these hearings and basically summarize the highlights of that report. And this can be some of the most effective testimony in the entire case. It's super important to have a good mitigation expert for a sentencing. Also, as we've talked about earlier in this series, when you are simply awaiting for your case to be resolved, there's certain rules that pretrial services requires of a defendant while the case is pending. And these can be all kinds of different rules. If you want to know more about that process, go back to an earlier episode. But the Pretrial Services Office all throughout the case has been keeping tabs on how your client has been doing leading up to that sentence. Is this somebody who's been complying properly with their rules from pretrial services, or is this somebody who's been totally blowing it off, violations, thumbing their nose at the court? Well, at the end there, leading up to the sentencing, we're going to get a comprehensive pretrial services report. When I say we, I mean not only the defense, but the prosecutor and the court. And so we need to look at those reports very carefully. Obviously, if we have a client who is compliant with the pretrial services orders throughout the course of the case, we're going to have even more mitigation on the scales. Judge, this is even more reason why he's proven that he can comply with the terms of probation. You don't need to send this guy to prison. Of course, the opposite can be true. This could be a talking point for the prosecutor. You see that, Judge? He screwed up his pretrial release multiple times. They can't keep track of him. He's thumbing his nose at this court's rules that they placed on him. He's not going to do well on probation. You got to send him to prison.
And, this also applies if the defendant has been incarcerated the whole time and has been detained. I'll never forget, I once had a case, and we moved to sentencing, and my client had decided that despite my advice that all the phone calls are recorded, decided to make multiple calls to people from the jail, all recorded, saying about how stupid the judge is, how dumb this case is. Wouldn't you know how fun that was to hear played over the courtroom loudspeaker, my client's phone calls, saying a whole bunch of really dumb, hurtful, even disastrous things to the court. Very hard to deal with that. But so, yeah, how you behave from beginning to the day of sentencing is definitely going to be something that's factored into the equation in terms of sentencing.
And when we have a sentencing coming up, finally, our favorite part perhaps is the oral argument that we get to give to the judge, summarizing all of these important mitigating factors. So we spend a lot of time preparing that oral argument, making sure that we're highlighting all the important points of mitigation for the court. As you mentioned, there's certain strategy to it too. You don't want to simply rehash everything in the sentencing memorandum. That's kind of insulting to the judge's intelligence. You filed this document, the judge has read it, presumably, and so if I want to highlight points, I'll kind of give a disclaimer to the court. Judge, I'm not going to rehash every point, but I want to highlight the important aspects of mitigation here. Judges appreciate that.
Yeah, and it's a great time to humanize your client, especially if it's a case that's gone along for a long time. You can say, look, Judge, I've had the pleasure of representing this guy for the last 3 years. I can tell you what an honor it is to represent him. We've become friendly. We're this, we're that. I mean, if you're technically not supposed to just offer personal opinions like that, with maybe one exception in my entire career, I haven't had a judge object to that. And it can go a long way, especially if the judge respects you as an attorney. You're almost giving sort of a character, a type of an endorsement without quite doing that. But again, you want every edge you can possibly get in terms of how you present this client to the court.
So yeah, in summary here, there is a ton of strategy that goes into sentencing. It really is kind of like its own mini trial on the question of what's the penalty going to be. There is a huge procedure involved, as I hope we at least highlighted some of the important points. As usual, each one of these subjects could be gone into much, much, much deeper, but this is a nice flavor of what a defense attorney should be preparing for when you're dealing with a sentencing.
Yeah, I think that's the goal with this series, right? We're trying to give people an overview of what it is we do, things that you can do that I think are be favorable to the case. And maybe it's the kind of thing that people watch, even if they have other lawyers representing them on their unrelated cases, it might prompt some questions to their lawyers about, hey, what about this? What about that? I heard Mark and Andy talking about this or that.
I've had that in my office several times where I'm meeting with a new client and they're like, yeah, I watched your video and I want to fire my current attorney because he's not doing the things you and Mark were talking about. It's like, okay, well, fair enough.
Yeah.
I always appreciate people getting a second opinion. Now, I think that we should spend a minute here talking about a few little niches that have to do specifically with federal sentencing, right? As we mentioned early on, there's state courts, there's federal courts. They have different rules. Many of this stuff is very, very similar for federal court, but there's a couple little interesting niches involved when you are representing a client in a federal case and you have a sentencing coming up.
Yeah, it's really surprising how few criminal defense lawyers are actually licensed to go to federal court. And you have to get admitted to go to federal court. Just because you're licensed in a state doesn't mean you can show up in federal court. Mm-hmm. And, we do have two different criminal justice systems in the United States, right? There's the one in your state, and then there's the federal criminal justice system. And, of course, far more cases are handled in the state system than in the federal system. But there's a lot of serious cases in the federal courts, and we've been doing federal court cases close to 30 years at our law firm. And so the federal sentencing is all driven by the federal sentencing guidelines.
Funny anecdote for the listeners here. I've been federally licensed for 10 years because that's how long I've been at the law firm. And do you remember, I actually got sworn in the middle of a federal trial. Talk about being thrown into the deep end. I wasn't even a certified member of the bar yet. And I remember we started the trial, and on, I think, day 2 of the, I wasn't able to speak because I wasn't licensed at that point. It was just you. But then day 2 of the trial came around, and I had some witnesses coming up, and finally I got word that I was licensed in Arizona, so now I was eligible for federal, and I had jumped through all the hoops, and the news came in the middle of trial. So Judge Bolton over in the federal system was able to excuse the jury, and in the middle of this federal trial, I was able to raise my right hand and get sworn into federal court in the middle of a federal trial.
You were truly forged in battle.
That's absolutely right.
But so it's all driven by the federal sentencing guidelines. And the federal sentencing guidelines, wow, we could do a series, and lots of people have, on the federal sentencing guidelines. But, they used to be, they're still important. They used to be far more important than they are now, but there have been some changes in the law that have made them, instead of mandatory, now they're advisory. So what this essentially means is there's a whole bunch of litigation about how they apply in a particular case. And you may not have agreement even on the day you walk into sentencing. So what will happen is the pre-sentence report writer will do a draft pre-sentence report, and then you'll look at it and say, I don't like how they applied the guidelines. And you might call them first and say, hey, I think you didn't apply this correctly. I think here's why you got it wrong. And they may say, sorry, I'm not going to change it. File a formal objection. And so you have to file a formal objection and say the pre-sentence report writer added a couple of points for this and that upward, which is bad if you're getting sentenced. We don't think it should apply for this reason or that reason, or there should be some points on the minus side to lower the person's score, and they didn't add them, and we think they should be added or subtracted, and here's why. And then the government will agree or disagree, and this doesn't get resolved until you walk in there. Mm-hmm. And then you walk in there, and the judge will say, okay, we have an objection, and it's contested. Mr. Victor, what do you have to say in support of your objection? And then I'll make an argument. The government will make their argument, and then the judge will make a ruling. And once the judge rules, the judge will go through the guidelines and say, okay, first calculation, here's where you come in on your final adjusted guideline level. And then here's where you come in on your criminal history. Mm-hmm. That's the other part of the chart. And that gets us to a recommended sentence of this many to this many months. And then all of this is just a recommendation.
Yeah, maybe we'll flash the chart so that people can actually visualize it. You'll see on your screen right now, it's kind of a matrix, and you'll see going up and down vertically, you're going to see the offense level. This is after we've calculated what is the charge that they were convicted of, all the enhancements and things like that, acceptance of responsibility minus, departures
that bring things up or down.
Up and down, points are added, and eventually you'll come to a number, and that number will be there on the chart in that first column. Then as you move right, that's your criminal history in the matrix. That actually shows you how many convictions, priors do you have in your past, and therefore how many additional points does it put you in. And that's when you end up in that recommended range. And you said very accurately there, Mark, recommended. How come?
Yeah, because the judge will just factor that in as one of the many factors to consider. And so the judge will say, okay, this is, the recommendation from the guidelines, but then I can consider anything else I want. The history and characteristics of the defendant and the background and parity with others and just a whole host of other things. And the judge can then give a sentence either higher or lower. And, across the nation, since judges have been given more discretion, it's pretty common for judges to give sentences below the guideline range. But there are times when judges give sentences above the guideline range as well. Federal judges have an awful lot of discretion.
Yeah, let's talk about that, because that is kind of the most interesting niche to me when it comes to sentencing in federal court. In state court, when we end up, all the different state jurisdictions have similar charts, maybe not as elaborate as the federal sentencing guidelines chart that we showed a little bit ago. Usually more smaller, less little factors to them, maybe category 1, category 2, more limited analysis. But when you finally reach that range in the state courts, most of them require the judges to stay in that range. Like if the end result of that sentencing chart in your state is between 3 and 5 years, the judge can't go off the rails and legally give a sentence of 6 months in prison or legally give a sentence of 30 years in prison at that point. They have to stay confined within that range. Whereas in the federal system, that guidelines is just a recommendation. It's basically saying, hey, judge, here's one of the many factors that you can consider. But if you want to go way outside of the range where they ended up after that calculation, be my guest. And we oftentimes do argue that the calculus that you reach a recommended guideline range in the federal system doesn't take into account certain important mitigations that are present in our client's case, and therefore we make an argument that the judge should go way below the recommended range.
Yeah, interestingly enough, the reason for this whole scheme is because of your right to a jury trial. We had some cases years ago that said the kinds of things in the federal sentencing guidelines that the judges find that increase the sentence, those are things that juries should find, not judges. And so when you let judges make these determinations, you are depriving the defendant of a right to a jury trial. And so in order to not throw out the whole federal sentencing guidelines, what happened was the Supreme Court said, well, they can stay, but they're advisory. They're not mandatory. It's just a sort of data point for the judge to look at, and the judge can do pretty much whatever the judge wants. But I got to say, since those cases, it's been a bit surprising to me how few federal judges have really thrown out the guidelines. They've still stayed fairly tethered to those guidelines, which frankly are much too high in several areas. And some judges have publicly spoken out about this, specifically in some of the drug areas and some other areas of the criminal code where they think that the guidelines really need to be recalibrated so they're more connected to reality in some ways.
Yes, absolutely.
There's another thing about federal sentencing that just a little fact that I think a lot of people don't know that we should put out there, which is you can actually be charged and punished for the same crime in the state system and the federal system. Now, this doesn't happen very often.
What? You mean double jeopardy doesn't protect me against that, Mark?
You would think that you can't be punished twice for the same crime. But in this one instance, and only one that I know of, where the federal government now recognizes the state as sovereign. They say, well, this whole double jeopardy thing, it just means you can't be punished twice for the same crime by the same sovereign. So you could commit an act that gets you tried, convicted, punished in the state court, and then assuming that there's federal jurisdiction, the federal government can now come in and re-prosecute you for the same act, try you, convict you, punish you, and tag on a bunch more time for exactly the same thing that you were just punished for in the state system. I think it's flat wrong. I think the law should be changed here. I don't think that's what the founding fathers envisioned when they put the double jeopardy prohibition in there. And why would they have? They never envisioned anything like the behemoth of the federal criminal justice system that we have now.
Yeah, it's just simply a legal fiction that the state and the federal governments are two independent sovereigns. It's nonsense. And yeah, I agree with you, but that's the current state of the law.
Yeah, so I think we should just put that out there for people to understand.
Yeah. Whew, well, that was a really fun video. Our viewers now know probably more than they've ever wanted to know about how sentencing works. But this is an important one because as we talked about at the top, most cases statistically will end in some sort of a sentencing, whether that's through a plea agreement or a conviction at trial. Yes, getting acquitted at trial feels much better than ever having to proceed to a sentencing, and that's always goal number one if the case goes that direction. However, it is possible to have big wins at sentencing. If there's a ton of prison time on the table and you can convince that judge to go on the far lower end of the spectrum, maybe even going all the way to probation, that really does feel good. And there's nothing like when you walk out of the courtroom in a high-stakes sentencing and everybody is worried that, you know, my family member is going to go to prison, my friend of 20 years is going to go to prison, and we're worried. And then you get to walk out of the courtroom with your client, everybody's hugging and thanking you, and that's a really, really great feeling.
Yeah, I don't know how many times you and I have walked out of a courtroom and it's been nothing but hugs and tears and just, even though, you know, it's not a victory at trial, a victory at sentencing can feel just as good if you went in there and you did a good job and the judge was teetering between maybe a long prison sentence or maybe probation and you convince the judge to do the right thing and give the person probation. It can be just as satisfying as a win at trial, which is wonderful as well. But like you said, the percentages are such that in the criminal justice system, there's a very high probability that you're going to wind up at sentencing. And that's why you got to work at it from the very beginning to make sure you get the best possible result at the end.
Well said, my friend. All right, guys, thank you very much for tuning in to this episode of Fighting the State. Be sure to go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. Also, check out attorneysforfreedom.com to learn all about our law firm and how we represent people in the justice system. As always, if you like this video, make sure to leave a like on the video, subscribe to the channel, share it with a friend, and leave us a comment. We'd love to hear from you. Until next time, this has been Attorneys Andy Marcantel and Marc J. Victor signing out. Peace.